Yes. You wanted to mention what? What do you want now? You are for respondent. What do you want? All right. What do you want, both of you? Any urgency? Is there? Execution. All right. You agree and take it by consent call on certain person. All right. You agree on it. By consent call on 5-0. Very well. 40. Five.
If I like so with 1% interest, award ಆಗಿದೆ.
This is petitioners. You suffered a arbitral decree in arbitrate. All. So but the parties have settled ಅಂತ ಎಲ್ಲರೂ ಬರ್ದಿದ್ದೀರಾ ಇದ್ರೆ ಬೇಡವಾ?
Full and final settlement of the respond, but ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲ ಅವರು. They have settled for this something.
So what have you said? This is an appeal arising out of a commercial. You must say something, or you must say that there is no other further claim. You are happy with that? No, if you are happy, no problem. We have no problem. We will put this on record and close the matter. Fair enough. No problem. See, Prakash submits that. Tama hesru Vasant Kumar. Prasad and Prakash and Vasant Kumar are the advocates for the parties. Submit that respondents have agreed to receive rupees 40 lakhs in full and final settlement of their claims. Full stop. The advocate for respondent has filed a memo which reads thus, with our witness called care number which reads thus. Full stop. Refund? Any refund is there? Court fee idea? Ilva? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ court? Then no problem. Nothing further survives. Appeal stands disposed of in terms as per memo. The file
Complaints ಆಗಿದೆ. ಆಗಿದೆ sir.
yes,
I-1 of 23 allowed.
I-1 of 23 allowed petition restored on board. What's on merit?
License question ಮಾಡ್ತಾರೆ.
Nimgen, how are you connected with this?
The residents of the village have training in the park, company, and the park is within the limitation of office.
All right, notice, they already filed. Then notice to private respondent ಹೋಗಿದೆಯಾ ಇಲ್ವಾ?
R7 go.
ಹೋಗಿಲ್ವಾ? All right. Notice to respondent number 7. I disclose. All right.
Recovery warrant in execution case, they have to listen to market, it is not challenge. That is, the time you take it, there is appeal can be 60 days, within 30 days, there is execution petition, warrant is issued, possession is taken, NPA and arrest warrant is issued regarding against action within 60 days. This is 60 days.
All right, you want now time to file objection. 1 week to file, as paid for one. By Amarnath, 1 week to file objection. By 1. Yes, will be. Next week on date for it. Ajesh,
The trial court is not to be followed up. For the contract. Three number one was already allowed, where I have complied. I should not go
I1 for direction. What direction?
for a stay of the execution proceeding.
24. Why it has come today? Admission.
EML.
Oh, yes, right. No, it's all right, but what is the stage?
Trial court records have been followed.
Right.
Any case is another case where the property at the date of filing the claim was only basement and ground floor. Later, the case is to deliver property.
Oh, yes, which are not there, you said.
Does not exist. They are claiming.
Sir, whether the second and the third floor is there or not?
First floor was in existence, but it was not in existence. It's very much clear in the records.
To leave about record, we are asking you. Now it is ground floor or ground here?
We have already delivered possession back to them. They are in possession of the property.
Oh, you give back what? Ground plus?
Whatever the premises, ground, basement and ground we have given.
Basement and ground.
Yes.
So he is claiming rent for first and second
First
floor.
and second.
Huh?
Page 147 on the paper was filed by there. That is, there are two lease dates, lease date and supplemental lease date. Supplemental lease date at,
No, you don't know what we want to ask a question. Why? How can you answer? You have a question to answer. See, now according to you, he has delivered basement. According to him, he has delivered basement and ground floor. According to. So you are saying that there is first and second floor.
Respect ground and first floor deliver, and he agreed to construct second floor over the existing first floor.
Fair enough. That's enough. So now first floor also must be in existence according.
You
Right.
demolish it, and from the
What did he demolish?
first floor demolition under the guise of renovation. Lots of these days coordinates construction of second.
No, do you have any photograph of that date?
Photographs are
First floor. See, this is a very highly contentious issue. So whether the first floor is there or is not there is a matter of fact which requires to be decided by either by evidence or by agreement of party.
During the course of cross examination that I have produced before the Honorable Court.
Saying what?
There exists the first floor and I was supposed to construct second floor. There is a clear admission on the part of tenant during the cross examination. That I have produced all the documents. My lord is called for the trial court record. On the next day, we both can make submissions and.
All. Now the records are here, have to be called for. Records have to be called.
Something called for.
All. Then the only matter has to be heard. Await this.
Euro, they have filed an IA to DSRB 35 lakh, 82 lakh.
This application is for a direction to deposit this remaining money, 82 lakhs, 93 lakhs.
120.
Direction from my lord, the ID number 1. I have deposited the area of rent as claimed by them. That is the order of my lord, which I have already complied with. They set on part complaints of subjections. In the periods of the urgency in the execution proceedings, this honorable court was straight.
All right. So now what do you want?
I should tell you, direct deposit to balance the decretal amount. I do after section.
That comes to how much?
That is, I have claimed in the executive for 4 crores 57 lakhs. 4 crores 72 lakhs is pending.
So now how much he has deposited?
35 lakhs 82,000. So it will not be 10%. It's very difficult because running the shop only on rent basis. He has come from the North India. He's doing what a minute. He has no permanent award and permanent this one properties. It's very difficult for me to return the amount.
Lord, in effect, you're asking for review of the order dated 9/1/24.
9/1?
9/1/24 of my lord.
1 minute, let us see.
Yes, 9/1/24. My lord,
1 minute, sir. Let me just see him. Correct, 9/1/20.
yes, IA number 1 of 23 is allowed. And as per Marla's terms, my lord, it's discretionary. I've been able to make out the case. If they are agreed, my lord, they will have to seek for in some other forum for review of this order. 9/1/24.
No, but see, what do you say? He has a point in law to make. 9/1/24, this court has considered and passed an order.
The reason I made this application. Deposit and balance amount.
No, that's a different matter. But the point is,
For proceeding. He just deposit 35 lakh into the, is not 10% of the total decretal amount.
here Mr. Ravi Sundar is it? Sorry, we can't do that. Because after having heard both parties, the court has passed an order. You will have to challenge this order in a manner known to law.
Section 42 is an independent provision. Which
Fair enough.
However, not been exercised independently.
Correct.
From that order, what I am seeking that.
No, we would only request you one thing. Please don't pressurize to change the, as far as practice is concerned. Because this is it says, the order reads as follows. Ajay Kumar, learned advocate for counsel for the appellant. Ravi Sundar, so and so are present physically. They have raised following objection, etc., etc. Then this order has been passed. Sorry, IA cannot be considered like this. No. These IAs, no. This order, you can challenge this order. There is no problem about it. It cannot be kept pending, sir. It has come for direction today. So either we must rule it, give a ruling on that, either this way or that way. So that's all right.
Wait, LCR ಅಷ್ಟೇ.
Await LCR. Personal data.
Respondent.
What is this? Objection for what? Have objection for 26 days, COB appeal.
So there is a delay of 26 days.
Yes.
They are not, stay application.
What is the stay about? What is the main matter?
IA ಮೇಲೆ ಬಂದಿದೆ.
Eureka Books supplies the sales and services undertaken with the warrant in private companies.
Correct.
Yes, sir. I do the servicing of this water purifiers in my area. The spare parts are secured from the very company that is Eureka Books and license. It's something like I have a roadside mechanic. I get the spare parts, like the services people and it's done. This is my business. Once an application that I should not do the service. The court says that there may not be any trademark infringement, but public interest is somewhere, therefore I am granting infringement. Please read out the portions of the order. This is the kind of order which is.
So who has gone to court
Eureka Books goes to the court
asking for?
asking for injection.
Infringement of trademark and not passing off the name Eureka Books as well as 19 other trademarks of the hand.
That's not the right.
What in substance? What has he done?
Database data. They impersonate, my lord, to our customers saying that they are from the Eureka House. My lord, they're servicing the parts. They are not a authorized dealer. They are getting these fake filters, my lord, from Delhi and so many other places, and some of them also manufactured here locally. Because it just show, my lord, these are the original filters, my lord, these are the fake filters. They claim that they've been procuring it from Eureka House. But nothing is procured from us, my lord. And this is just the tip of the iceberg in terms of how they're operating. And my lord, there's a criminal case filed, my lord, in 2018. My lord, the respondent number 2 was enlarged on bail. My lord, there are 4 other entities. One entity they get caught, my lord, they start another entity. When we just pass on these, my lord, only to show. They
This is
claim
not like
that
an
procure
asset
from
problem.
us.
This is more like asset problem. What is
Okay,
it? Now I just indicate what they want to do. These are all the people. Before records of finding, we cannot go beyond the finding which is recorded by the bank. Bank would say that you are only into the business of service. You don't sell the products. You are not claiming that you are an authorized service provider of Eureka Books. That is specifically finding the record. That's the reason why I said I do parallels with the roadside mechanic. I don't claim myself to be an authorized mechanic. I'm a roadside mechanic. If anybody is interested in availing my services, I will render my services. That's essentially what I am doing. Now, what he says is that whoever wants to deal with the products which have already sold, they should be prevented from servicing the products.
Whoever,
Whoever wants to service the products which are sold, they should be prevented from doing this. Unheard of. Where is any question? This is essentially what I meant. If I purchase a Maruti car, I can go to any roadside mechanic and get it repaired. How can you regulate that? It should be brought to an authorized service center and got service.
maybe perhaps his case is that it's affecting your AMC. Is that right?
It is now there is no guarantee of business. I can assure this not to be good business. Under no provision of law, there is a guarantee of business of AMC. He is entitled for his IP rights protection. Let him keep it. We are not bothered about it. I don't say I am Eureka Fox. I am not saying that I am selling the products of Eureka Fox. I say that the products which are there in the nature of water filters, whether it is belonging to Eureka Fox or some other company, I have the wherewithal and the expertise to service it, and that is what I am doing. If a customer is interested in taking this and servicing it, I do not understand as to why they get. This is the essential reason why it's a carpet bombing. Now, what they are essentially doing is they want to finish off all the service providers. Now, it is something like this. If I were to take my Hyundai car to the authorized service center, they will charge me 5,000 rupees. If I can get it serviced at 800 rupees, why not? And that is what the court says that this is where public interest is suffering, because if you get it serviced with this 800 rupees service mechanic, the quality of the car will be doubted in the public eyes and car. This is the kind of findings which was recorded by the client. Absolutely absurd. It is up to the customers. If I am representing that I am the authorized service center, that I am Eureka Fox, then if I get extra required to be put, I have absolutely no difficulty about it.
How do you respond? No, we will not touch it. Please, no. Purely questions of fact, questions of law here. Ravi's case is simple as that. Sir, I never claim myself as so and so. So, what is your plain government? How did you go? What did you say in your plain?
They there were 2 people, Balaji and Anand. They both are related. And they started the company maybe in 2013 or 14, but 17 and 18, company received a lot of complaints from customers saying that somebody in your name is coming in doing services and they're installing fake parts. And around 2018, a complaint was filed, a detailed charge sheet over 250 pages was filed by the police, Jayanagara police station. They've been enlarged complaint. They stopped doing business in that particular lane. Now the latest company opened by Balaji Kumar is Swega Forbes Private Limited. And this is Forbes Technology.
I wanted to say this,
16
Eureka Fox is not before the court. Very convenient. I am operating in the name Fox. I own Extra Sense Private Limited. That is the only company which is functional now.
That is the company, in 2018, where a criminal complaint was filed against the company, they stopped operations in that. And the drop of a hat, they changed the entities. We have enough material to show. Name Aqua Ion Existence, Hope. Just drop of hat, they keep changing the invoices. They are doing business in cash. And even hundreds of complaints, nothing would materialize. No customer will come forward to go to police station. They would leave it as 2,000 rupees to 5,000 rupees probably per case. My lord, out of this 100, my lord, if 10 decide to go to the police
No,
station, my lord,
all that is fine. But you see, how will you counter his argument?
he's not doing it. I can understand. And they'll have the same example. My lord. Maruti Suzuki, my lord, has dealership.
Correct.
We also have hundreds of franchisee business
Correct.
partners under whom we
Correct.
recognize them. And my lord,
But Maruti is also being repaired by several people.
Unauthorized dealers also. Unauthorized dealers.
It supplies major automotive parts. They have their own service center. But we cannot stop Bosch from
See,
servicing or-
I think you are glued only to Bosch, Maruti, and go to some village side. There will be some ABC repair work. Where will Bosch come there? We are not on that. Please, I think you must. Your plaint maybe will come to that. They're asking you one question, fundamental. See, supposing you take to a rural side, there's one small mechanic sitting there. You have what you said, your Maruti only. So if the Maruti car is not working at that point of time, he comes and then repairs whatever that he does.
They're not stopping any customer to say, hey, please don't go to any.
Correct.
We never done it.
So what's your problem?
What happens is, they do not manufacture the unit.
You forget about him. What is your problem that A goes to?
My name, they stolen my data.
Using their name.
Service in my.
Where have you said that? Please show in the plaint.
Yes.
But the finding was specifically recording that the service is being done in my own name. It says that you hire a service.
Name
your
of
products,
birth,
that's
now
what
it
we
is
do.
different number 47.
So this is how it is. In the absence of a contract between the plaintiff and the defendant.
Where at page number?
At page number, page number 32, internal page number 11.
Very well.
Because after about 4 lines from the top, the
Right.
sentence starts in, it is not the case of the defendant that they have taken plaintiff franchise to extend annual maintenance service to plaintiff customers with regard to water purifier. In the absence of such contract between the plaintiff and the defendant, entertaining defendant's contention amounts to allowing them to enrich themselves with the cost of the plaintiff's business and general public health at large. The circumstances establish irreparable injury that may be caused to the plaintiff herein and public at large. Person who seeks equity must do equity. Defendants are required to perform their business in accordance with law enforcement. Plaintiffs have also produced documents like FIR and defendants for attending services of their clients in the name of the plaintiff company. Such attitude of the defendants required to be needed the part. Primary patient plaintiff established its case for not of temporary intention against the defendants. So far as I am concerned, I file an affidavit that never will I claim that I am an authorized dealer or an authorized service provider for your companies. I file an affidavit of undertaking before this one will court. But my entire business is come to a standstill because I have a workforce of 200 direct employment and about 1,000 indirect employment I have provided. Because this is a business. They cannot provide it. Now, essentially, there were so many mechanic shops which questioned because when Bajaj Chetak was there, every gully had a service shop because Bajaj Chetak was charging 200 rupees for a service where these people were servicing at 50 rupees, 60 rupees. There is nothing wrong. If there is a product which is given by them and if they are charging exorbitantly for the annual maintenance at 5,000, 8,000 rupees for a machine which they are given at 15,000. I will service it at 4,000. I find an aspect of undertaking, not that never ever will I claim that I am
They have also
and the name of
presented documents like FIR registered against the defendant for attending.
Ravi, where you read page 32, please come to where you stopped,
Yes,
little further.
such an attitude of the defendants.
No, one sentence prior. Plaintiffs have also produced.
FIR registered against the defendants for attending service of their rights in the name of the plaintiff company. But that's the reason why I am saying, because we have never done any business in the name of plaintiff company. We have got all the invoices because we have used the invoices saying that in none of the invoices we had claimed that we are in any manner connected with the Eureka folks. I have raised the invoices in the name of my company. Because if I raise the invoice in the name of Eureka folks and take the money, then it's a different matter. How does the court come to this conclusion? Because an FIR is registered, they could manage that an FIR is registered and a charge sheet is filed to the police. The court wants to conclude on the basis of the charge sheet materials in a civil dispute. Absolutely independent materials are required to be considered. They cannot look into the charge sheet. That is the
A
law.
lot of police take the even fight till date. In fact, my lord, I have a couple of audio which make sure this item which was also produced before the trial court when granting the injunction order. Injunction order was granted on 11/1/2021. Till date, they violate the order. And my lord, there are 4 concerns, my lord, the equal disobedience, miscellaneous matters which are pending, which is being state cross examination. And my lord, at no point in time, my lord, they claim that they are, my lord, bona fide, my lord, businessmen. They are only thriving. They do not manufacture the unit.
May I just
And if
ask-
they don't manufacture the unit, parts also they cannot manufacture. And they have to stay from the invoice. My lord, once I have, my lord, it's my product, I have the right to give it to whoever I enter in agreement. My lord, he cannot buy 4 parts and say, I am the service, authorized service agent, and the other part, my lord.
That's the point we are asking. Where has he
Customers are going to.
said that he is your authorized dealer or authorized serviceman?
He's not claiming any of those.
Then?
He, my lord.
Then how can you stop any mechanic from
No, he's not the mechanic, but because the mechanic has his own shop and people go to that place, not it's absolutely fine. They, on the other hand, not read my plain government, page number.
No, Mister. No, we always speak on principles and positions of law. Then final thing.
Registered trade.
Correct.
Their company name is Forbes Technology Private Limited, and they're doing business in the name.
Private limited.
Yes, my lord.
So the company has permitted this.
My lord,
The name has been cleared.
in terms of so far as that infringes the trademark of the plaintiff per se, my lord. And my lord, here in this case, they approach our customers, my lord, under our name, saying that we are from Aquaguard, we are from Eureka. It's not the customers are going to. That is the difference, my lord. In fact, they've stolen lakhs and lakhs of customer database. They call the customer, my lord, and say we are from Eureka folks, and then they do service. And subsequently, when the customers realize that they call the actual customer care and say, look, this is what has happened. This is so and so person had come. This is the invoice. All those documents are produced, my lord, in the trial court. Even my lord, so far as Forbes Technovative, in a written statement, he says Forbes Technovative is still not operative in India because they have not obtained the trademark registration. My lord, on the contrary, the contempt, my lord, the exhibit what we filed, it is in the name of Forbes. That itself is violation.
Because I am making a statement. I will not do any business in the name of the plaintiff. I file an affidavit of undertaking. But I will not do anything in the name of the plaintiff. Because I can produce the document. This document was part of the record. We produce documents to show 2 things. Number one.
All right, bring whatever that you want to say. Both of you bring whatever that you want. We'll hear and
Business is shut down. It's all technical people. What happens when I remove them?
all right. When will you? Fair enough. When will you file?
2 weeks time is all I'm asking because the documents were released and my lord, for the first time in this appeal, my lord, they have taken cases and contentions which are not before the trial court. Even documents which they are referring to.
Islam has gone properly.
No, my lord. In terms of, I should have the benefit at least to counter these
All right.
cases what they're talking about.
All right. 10 days going to take for in between. All right. As prayed for by you are appearing for
The plaintiff is appearing for the.
R1 plaintiff. Mr. So and so appears for R1 plaintiff. Accept notice for R1.
For the other respondents, it may be discussed because it's only the plaintiff's application, my application is discussed.
All right. So you are for appellant has filed a memo seeking dispensation of notice. R2 to 5. R2 to 5 ordered. Right. Thank you.
Great.
This IA1 will close, Mr. Yes. By consent, I am allowed. No objection. Yes. Close document. Yes.
Perfect.
Yes. What is this matter about? Oh, advocate general. One is closure order.
direction of this page 23.
What is the direction?
Direction is, extend power from the constituent 1C of the water prevention and management. Direction is prohibited from discharging the effluent in the act. But order will be noted to next page 23.
No, you are aggrieved by one is closure, one is direction. So direction is
Not to pollute.
not to. So direction is not to discharge water.
Well, next study, page 25, the closure order under section 33.
Right.
Was 33, 1C, 1 ARB.
So what is your main ground?
Not the next study is not without really.
Annexure C is closure, is it? Prohibition.
From discharging the effluents.
Is passed without hearing you.
Secondly, under the act, the order has to be passed with the court.
Who has passed in this case?
First, the respondent.
Pollution control.
Is he a delegated authority?
For under section 11, the delegation is only to the chair.
12(3)(b).
Okay. 12(3)(b). Twelve three B is clear.
But the secondary guidelines in our have is that this order is passed without hearing. Though the section do not contemplate that parts the voting should be given. But the natural justice demand that parts they should write minimum so far. Though this order is running on the votings, actually to page 23. The operator provision is page 23 and actually.
Yes, page 23, annexure C, correct.
Though it is termed as voting under section 32 1C, the not will find it in page 24. The order. In excess of powers under section 32 1C, according to you are hereby henceforth prohibited from discharging the effluent to the limit of public and
So what do you want now?
before March and order of this center was to be passed. Second, annexure D.
What is annexure D?
First is the closure order.
Yes.
But the shoulder notice was issued. What's the connection here, page 30, on November 2024, in page 30.
Yes.
Well, connection B, 17/1/24.
What is that?
Well, I declare. Bottom line, 19/1/24 is the development, by the respondent within the reply.
Annexure
B1, page 15.
1.5.
Well,
Yes, 19.
19 months I filed my reply, because I was asked to reply in 7 days, I assumed it on 30. Within 25th, the order of board that is passed. Next study, page 25. If you want to go to the page 25, next study.
What turns on that?
First, my objection, right, is not put up before the board, number one.
How do you know?
But there is no reference to my objection. My lord went to see on the next study, page 25. The last thing which I noticed is 3/1/2024, and in the include order also, this 11th Shokas notice is mentioned.
Any
And personally, was not granted on this, because
is it contemplated?
well, it is not granted, but the
Inbuilt.
absolutely not segment of engineering is more or less identical situation.
Inbuilt.
Respondent part was of the party. Page 28. And by the objection of all, you know. I can feel a case that even my reply is transferred. But Annexure B,
There is no appeal on this?
well, I have come before the logic, two grounds. One is not in the absence of complete jurisdiction, or secondly, violation of competence.
The jurisdiction he has. No?
But even then, the second ground would be not the natural justice, there is a violation. Even if the law does not provide not say, hearing the Shukla notice, as it came upon Annexure C, where the order of violation is passed. Or I should have been heard in the matter, with a minimum 7
Yes,
days.
that's our start point. Yes, Shashi, what I got?
So for the appeal is 33B. And
But now his grievance is with regard to,
here whatever we said, don't pollute. They cannot say that I will pollute. So before they can't be, they have taken that right to pollute is there. Ultimately, the order is that you don't.
so but he has stopped also. No? Closure.
Don't consent for operation of the operate.
We are not operating. We are-
That is the point.
But we are only running the trial, therefore I said, next step B, that is like, where I have disputed each of the spots, which was very important. for-
So what is your occupation? What do you run?
But I am establishing ethanol plant.
What plant?
Ethanol.
Ethanol.
And we are on a trial run basis. Plus, we are not using any commercial. Therefore, this is what I have said in the actual B. Reply.
What I said?
But when I take the page.
No, what I said in annexure B. Right.
Point by point, I have disputed the claim of sponsor.
So what stand have you taken?
Exactly, it is, I am not doing commercial, because I am. And I have put in in the proper place, there is no leakage of evidence in many times. These are the things which board is instructed the person.
So you are not running a industry at all.
So, if you look at trial cases,
Fair enough. Fair enough. Now you are doing the trial runs. Even while doing the trial runs, there could be some effluent. So what is to be done?
First, I have taken that one facility reply notice, which they have to inspect. My reply is on 17 month. Subsequently, there is no inspection. They came to inspected on 3-1, which is much prior to the issuance of your notice.
3-1.
3-1.
Where do you get in the order?
First, kindly come to include or not in printed page.
18-1 order, no?
Yes. Include or-
That is annexure C.
Serial number 7. Next.
Closure.
Next, D on serial number 7, which is
Correct.
inspection of the industry at Kalburgi on 3/1/2024. The inspection report dated 11/1/2024. Seven, or the issue is local notice. On 19th, I reply. Either they should do further inspection based upon the reply, or they should personally hear me to decide whether my reply is acceptable.
What does this say? This annexure D.
Well, the next study, focus on the inspection report, not even the objection for which are under the next study. And you also got kindly come to page 27. But unnumbered paragraph.
Yes, yes.
To verify the status, industry was inspected by DO, RO.
Page.
Not page 27. Inspection.
Correct. To verify status.
Yes, verify status, the industry was inspected by DO, RO, reference number 7. Reference number 7 is inspection report dated 3/1 and 7/1. I need to show that. These are the observations.
Yes.
Then, thereafter, on going to page 28. As the industry is operating import plan and then the board 25/24, it can consider the rate prevention, discharging the plant emissions into the environment. Regional commission has recommended the board to issue further direction to industry. Whereas the board has already given a opportunity of grading the industry on 21/3/23. This is much prior to issuance of paper notice, because the industry was having a 3,500 capacity. Now they increase now, they have gone for 5,000 capacity. This is hearing is nothing to do, what is another. Where not, report show that only, not, I was given the past. But it's completely motivated for the illegal order. All I'm saying is not, if they want to redo, they can redo. Issue of notice not, they will go, I reply, I'll same reply to the answer. But these are the drastic measures where 1,000.
No, but the board also has a point. In the guise of this notice or otherwise, you can't be permitted to keep on polluting the place.
Yes. If they want to take an action in terms of law, they let them follow. This is what the other opinion of said. The identical matter not where the case is here.
What did it say?
First, what you can tell you, page 32. This is the underwater treatment. This is 1.78 hours.
Page 32 of what?
Synopsis and list of relation. The final property.
Synopsis and citation.
Yes, you have. Yes, page 28.
28. Not the fact.
Hmm.
No, the page 8, 34 is the conditions of the
Right.
Before the case of violation, the learner comes to applying for the response. Paragraph 3 was.
Yes.
When the government attempt to support the action of the authority, the submitting before the court, the Shokar notification 961, there is already a reference court. They take a 162, the person hearing of the court was signed on 21 to 23. As to act, the petitioner discharging from appellants, discharging appellants to nearby water channel in violation of that. Firstly, the second is to help of that and hence order dated so and so. They are unable to accept the petition of the Lanet Council in the response of the 194. There cannot be any proposition that authority is restricted power to take appropriate action, including the passing the penal order, everything is just concerned to stop the industrial activity. But really, is to follow the principle of natural justice. To provide an opportunity of hearing to the party. Now, the cost of limitation, we say that when the respondent board itself issued a shortcut notice to the petitioner interest and time system, informing the petitioner that the issue being a objection within 15 days. But then turning its back, stated it is already inspection was carried out. Fortunately, of being close to section 33 of the forum, not being allowed the petition. Partly the final of is understanding and to be the shortcut.
Correct, we got it.
Now, I'm not the only person here. I will take issue showcase. I find a reply disputing the claim of the showcase authority, saying that I am not challenging. The senior is a pending consideration before the board. If you look at prior, in review order study, none of the points are present. We not even placed. I made a specific argument in my declaration. So they have rectified the application. My contentions that after my replies, I will not put up before the board. I specifically given in my petition, which is not disputed. All I'm seeking is let them do. First, hearing of a petition will not be specifically provided under the act, but the consequences are that leads to closure of industry, very affecting my national liability and also the thousands of workers are there. So they are bound to find rules on methods.
Yes, Shashi. What do you want to know? Would you like to have a second inspection done?
The reason is this. First of all, there is no consent to operation. Another friend is violating the law continuously by saying that I permit me to continue when there is no consent to operation. How is it? We cannot go 2 years trial run. Trial run means 1 month, 2 months, 3 months. 2 years is my trial run. It's never ending trial run.
But when did you establish this?
It is
2021.
21. Still
2021, you purchased the unit.
21.
I just
No, we just want to understand the fact. 2021, you purchased the plant. Then doing what?
So then we applied.
Yes,
And once I wanted to establish a 5,000 capacity plant.
right.
I applied to the MOU of serving for years. One day time hours, I applied for the respondent board. In 21st of November 2023. It is still.
For what? What did you apply?
The operation.
Consent for operation.
You see in the environment clearance.
It's still coming. But all I'm saying is, the finding recorded by the.
So if that means you don't have the consent.
No, that's, I'm saying, for prior consider not, expert parts, the board is expected to do the statutory discharge of official function. They can provide a finding that you have filed a show that you are replying to the notice, you are replying to this, it is not in accordance with law. And we hear you and reject your claim. Now, first, with respect for us, substituting a finding by the honorable court, I am only on that.
We understood that. The point is, according to you, your matter is pending consideration, your application is pending consideration with the board as well as MOF. So what?
No, that's not ordering a closure without hearing.
No, forget about it. You are not doing anything.
First, it's not the question. First, I am doing the paragraph. First, have they said in here, into order, that first, I have been doing this for last 2 years without permission. There is no such finding. Now, learned advocate general wants to improve the order, now this is contrary to one case. You can't supplement the extra evidence to support the illegal order.
Can't file an affidavit. So that's a settled proposition. That's not. But coming to the bare facts,
First,
it's not in dispute that 2021 you purchased this factory, existing factory. So now we are in 2024. You should have had the necessary permissions.
We are operating because we are going on.
So the law requires that till you have the permissions, you can't run the factory.
Commercial exploitation is nothing. I am not that for commercial business. Therefore, I request kindly take national details to be. Each point.
550.
1.
15. Yes.
One point national detail. So this is my apply to the Shukla notice getting never now. First point, the industry was in operation at the time of inspection. Immediately manufacturing sugar. This will be operating without CH-1 before. This is what the point number 1. The industry was in trial run and was not involved in commercial production. CFP expert application has been submitted to respondents by way of letter 2/11/23. It is also the process of obtaining permissions of service. You have started getting the shape from 28/11 second conference, 28/11 operating ethanol distillery from 4/12/23, operating in Indian manufacturing distillery activity before Saturday is can be over. It is violation of 25 which attracts problems of function. Industry was a trial run not involved in commercial production. Here the explanation has been submitted to case Mrs. Storage. You have installed a PTP of a capacity of 1500 kV, which is in operation, not contained the logbooks containing PTP operation. PTP capacity of 1600 kV was implemented pursuant to this is on the trial. Stagnation of regulate was observed here. The ISA has been verified. But without the reply, I have to what I am thinking is reply not because you put the board. If reply not before the course, ultimately not I don't do the practice. Point number 1 yes. Point number 1 is advocating the problem. So they are entitled to say that.
So now shall we record your undertaking that you are not running the plant? Then they will consider this. No commercial.
On trial.
You don't do anything. We will direct them to consider this and pass an order. See, you must have a very, very fair stand. If you say that in 2021 I have purchased, my application is pending with the board and also MOF. No problem. Let them come here or whatever that they want to do. Till such time that you see, you will not be able to do anything.
On trial run.
You take instruction. So we are clear on that. Take a fair stand. We'll ask advocate.
But they have to reconsider the stand which are taken.
No problem. But the point is, Advocate General stand saying that pending all this, I'll be doing some activity in that. Sir, it's a very dicey thing because one will say what is commercial and all. Is it reconsider madodre? You take a very fair stand. We'll consider if we can give you that. No problem. No problem. Of course. Don't do that. Anyway, we will not unnecessarily touch it because AG is here. We will just take it day after tomorrow.
Somebody else started changing because the petitioner has purchased the I don't want to get into this.
After saying I don't want to get into
No, I
it,
think
get into it. It's
Yeah, I think it's so.
it's behind. The question is, fact whether it's polluting or not, he doesn't answer that. Even you have to ask,
ಎಲ್ರನ್ನ ಮಂತ್ಲಿ ವೈಸ್ ಎಷ್ಟು ಟನ್ನೇಜ್ ಕ್ರಶ್ ಮಾಡಿದ್ವಿ ಅಂತ ಡೀಟೇಲ್ಸ್ ಕೊಡ್ತಾರೆ. ಕಮರ್ಷಿಯಲ್ ಮಾಡ್ತಾರ ಟ್ರಯಲ್.
No, we have narrowed down the so day tomorrow we'll see.
Parliament of Prejudice is not required the fact whether it's polluting, has it got permission or not. Let him not divert the point.
So how much he has crushed per month and all, we can ask. That's a different matter. All right, day after tomorrow. Thursday. Come back.
39.
Preliminary hearing.
39.
39.
Direct signature directed the orders be passed are the orders are already passed. There was no interim order operating.
So what is the matter about? He was a
ದರ್ಶನ ಪಾತ್ರ.
And Daiva speaks through. This is there were certain serious allegations against him. Inquiry was conducted by an independent inquiry. He initially participated in the inquiry, then staged a walkout. Then inquiry officer gave him a report to seek for reopening the case and participating in the case. He did not do so. Even the learned single state observer at page 20 that he was given enough opportunity before the inquiry. Page 28.
yes.
Inquiry after which the petitioner has not availed, therefore, the petitioner cannot contend that there has been violation of principles of natural justice during the inquiry. Well, thereafter, the inquiry officer submitted his report to the managing committee. Managing committee accepted the report and passed an order of dismissal on 20/11/16. This order was not challenged for 5 long years. Instead of challenging that, he filed a writ petition questioning some communication between the authority. There, in the writ petition, he found that he cannot get a relief unless he challenges the dismissal order. Then he files an appeal before the competent authority. In the appeal, my lord, this is what he makes the allegation at page 220.
He's in a temple or something.
ಟೆಂಪಲ್
It's a temple.
ಕ್ಷೇತ್ರ ಕರಾರ ಸೇವಾ ಸಮಿತಿ.
My lord, page 220.
So finally, what happened?
My lord, finally, my lord, the appeal was dismissed. Against which he files a writ petition before the competent.
Correct.
My lord, now learned secretary finds, my lord, that after the inquiry report is furnished to the managing committee, copy was not made available to him, and therefore the principles of natural justice is violated. That on that ground he has remitted the matter to the
ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು ಮತ್ತೆ ತೀರ್ಮಾನ
My lord, here, my lord, page 220.
He's saying after this, what has happened now?
After this, the authority considers the matter and their reinstatement be back into service.
My lord, this order goes, my lord, that order also goes. It is an order of remand. Therefore, if the initial order itself is wrong, that order has no restriction.
No. After this remand order, what
Yes.
happened?
Order is challenged before the proper authority. That is challenged. But if this
No,
order
sir.
goes,
No, sir. There is a remand order.
yes,
So according to Ravi, what's happened is, post this order, it's been given effect to that. You see, he has been reinstated in the.
yes,
On what time?
on the basis of this order. On the basis of this order.
But inquiry.
This order goes
No.
to-
Inquiry has been. What about the inquiry?
Inquiry is not conducted. He has passed an order.
But I just.
No, my lord, I will,
Inquiry was not.
Yeah, complete boundary. I mean, Kelton.
now he files an appeal, 228, page 220, paragraph 9. He is not at all an aggrieved person.
220.
Yes, paragraph 9. Why you are protecting this order before the he makes this government. Paragraph 9. It is submitted that appellant has not challenged order of dismissal as he did not want to continue with said course where he was not treated respectfully and he was personally hurt and humiliated. All the allegations made against him, he left it to the deity. Therefore, my lord, he did not challenge this order. Why you long here? He said, my lord, I leave it to the side. Now, paragraph 17 of the 224. Now, why is he challenging this order? Paragraph 17.
17.
17, page 224. He is not challenging because he is negative. It is submitted. Your lordship,
Yes, yes.
it is submitted that appellant is
By
now
devote-
challenging the improved order as he is being forced by the devotees
Devotees.
and the villagers. This is why he is challenging the Lord. He was not at all agree. He did not challenge it for quite long here. And now he is challenging because villagers are forcing. He is not at all a negative person. Therefore, he also did not complain before the honorable court, my lord, that he was not given an inquiry.
So this your respondent number 7 in the before the single judge.
Yes.
5, respondent number 5.
Yes.
So how are you connected? You are the
My lord,
secretary.
I am
He is the secretary.
I am the Seva Samiti of the temple. My lord, I have participated in the appeal proceeding by filing an.
So what do you want now?
Pardon?
What do you want now?
My lord, this order should go, my lord.
This order will go. Then
Then, my lord, that order naturally goes.
which one?
Following order.
Reinstatement.
Yes.
So then what should follow?
My lord, he is no more an employee.
No, but there is a remand order, no?
It is a remand order, my lord. The remand was not contemplated in my letter. Because, my lord, he was not at all an ignorant person. He was 5 long years he kept quiet. My lord, he challenges it because villagers.
ಬಂದಿದ್ರೆ ಇವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ವಿಲೇಜರ್ಸ್ ಡಿವೋಟೀಸ್ ಯಾರು ಕಮಾಂಡ್ appeal then
But the honorable single judge has considered and in his wisdom.
He has considered, my lord, there was no proof. And, my lord, which he says, my lord, he is not an agreeable person. He has filed because villagers forced him. My lord, where is the question of punishing him with the copy of the he cannot complain. Thank you, Lord. He was not at all agreeable. He had
person
accepted
and the
the-
single judge he deputy commissioner he is not in they have not filed the challenge with the order. Actually, the direction is against these people. They are not challenge him together. Real agreement.
But at best, you have a very weak link in the sense that you are only a secretary. The mandir belongs to the government, na?
It is a public temple. Everybody has got a right to the affairs of the temple.
So, but in any event, it's a Mujarai temple.
It is a notified.
Notified. Public temple.
So, your thing will be very, very. You have a.
Lord, that is not the ground on which he was denied.
No, you are not
I have
denying.
participated in
But,
the appeal
but the honorable single judge has not done any harm, he has simply said that you,
That was not contemplated at all, my lord, merely because the order should be legal, my lord, is correct.
but a remand order,
How could he has to explain how he is aggrieved.
that's also. Right.
Sir, you are aggrieved.
My lord, I am the.
Real aggrieved persons are the commissioner and deputy commissioner, assistant commissioner. They are the aggrieved. They are not in appeal.
Allegations are investigation. Yes. He has harmed the sanctity of the temple. He has misbehaved with the devotees and the staff. These are the allegations that are made. I am the person who has brought this to the knowledge of the managing committee. And
So,
the inquiry was.
then at least after giving let us see, what is the final direction? Give him a copy of the order, reasonable time to supply his, yes, at least that could have been done properly.
Lord, that was not contemplated. The situation, Lord, did not contemplate the remand at all. Because he was not at all active. Now, at the instance of third person, he is complaining. He did not complain for 5 long. Lord, why, what he was active for? If he had finally.
You pay him salary or something?
Yes, no.
Yes.
No, according to me, my lord, it's
An
not
annual
the.
remuneration of 15,000 rupees is paid. Annual remuneration of 15,000 rupees. What will this? It's a hereditary seva. 15,000 rupees. Annually it's given. No credit, it's 15,000 rupees annually.
Tribal ಪಾತ್ರೆಗಳು ಇರ್ತಾರೆ. ಅಷ್ಟೇ ಏನಿಲ್ಲ ಇದು. ಇಲ್ಲಿ ಹೋಗು.
So, no.
Focus is
Huh.
He was the chairman of the managing committee. Notice, he was the person who got was the initiator of the proceedings.
Who?
He present applied before the Lord's Sense.
Hmm.
So now he passed the order of dismissal. Managing committee, for Lord's Sense to see, he was the one who passed. Now, why he wants to come in this personal capacity? He did this. I will read it. Kindly have a look at page 126.
Yes.
This is the proceedings of the managing committee. Notice page 129 is the title copy. At page 131. ಅದಕ್ಕೆ ಕೆಳಗಡೆ ಯಾರು ಆರ್ಡರ್ ಮಾಡೋದು ಅಂತ ಕೆ ಶಂಕರ್ ಮಾಡ ಅಧ್ಯಕ್ಷರು
Was then.
ವ್ಯವಸ್ಥಾಪಕ ಸಮಿತಿ. It's taken it too personally. Managing committee is not before this honorable court. He is not the complainant. The managing committee had taken up this decision. Managing committee lots of taken. Now he wants to take things very personally. Ultimately, not the services required for the temple is what the subsequent order says. But what the learned single judge has done is only this. Not the learned single judge says that if the inquiry report itself is not given, and then second show cause notice is not issued, it violates
Justice ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
because it's a matter pertaining to service. So therefore, you have to be given with the inquiry report, hear him, and their contentions were also kept open. Now that order has already been passed, notice by the competent authority, may just pass on the copies of the order.
This is question.
Because they have already challenged that order.
It's not a problem.
I'm just submitting, now I can understand. But they have already gone before the competent authority and they have challenged these 2 orders.
Which order?
The order with
The statement order.
Single judge. So he cannot pursue parallel remedies. He's already gone there. He should have desisted himself from filing an appeal if he wanted to pursue the present.
I had tried it even before that. And, my lord.
I just
Yes, yes, please. Yes.
This was not at all made as a ground of attack in the writ petition. That inquiry report was not published. Therefore, it is violation of natural principles of matter. This was not, my locus was not questioned anywhere. And thirdly,
Page 26, running page 26, the findings of the learned single judge.
and it is not the case that he was not aware of the dismissal order at all. He says that I had left it to the diet. This is what is contained. Now, if this order, this is the foundation. On this order, on the basis of this order, subsequent proceedings are taken.
Para 5. Para 4 is the submission of the petitioner. That's the personal score before lawsuit. Para 5 was the stand taken by the fourth respondent. The fourth respondent is. The committee, the managing committee. Why is administrator? Because now there is no managing committee, there is an administrator. The stand taken is at page number, paragraph number 5. Second part of paragraph number 5. Insofar as the non-publishing of the inquiry report is concerned, Learned Counsel appearing for the fourth respondent would admit that the inquiry report was furnished. He would contend that it was not necessary to be furnished, and the attitude of the petitioner was that he was not interested in continuing with the post in the light of the allegation. This is essentially what was submitted to the signature. Page 26, internal page 5, paragraph 5. The last 6-7 lines from the bottom. We start with insofar as the non-publishing of the inquiry report is concerned, the Learned Counsel appearing to fourth respondent would admit that no inquiry report was furnished. He would contend that it was not necessary to be furnished as the attitude of the petitioner was that he was not interested in preparing the post in the light of this allegation. This is essentially what was stated. Now, what is my kindly take paragraph number 9.
Yes.
Totally they were violation of principle of natural justice.
The inquiry was reported 14/2016 only with allegations against the commissioner. 7R2. Said inquiry report is placed before the committee of the management, and the committee of the management accepts the report dated 14/11/2016 and passes an order of dismissal from service against the petitioner on 20/11/2016. It is the aftermath of the conduct of inquiry that acts of the respondent managing committee smacks of violation of principles of natural justice, as the report of the inquiry officer was never served upon the petitioner. He was not afforded an opportunity to reply to the content of the inquiry report of the inquiry officer. He was not served in the order of dismissal either. Merely because the petitioner did not reply to the notices, nor did participate in the inquiry, could not absolve the duty of the managing committee to serve the report of the inquiry officer and seek the defense of the petitioner and serve the copy of order of dismissal. Lordship may kindly mark the next sentence. It is an admitted fact that the report and the order of dismissal was never made known to the petitioner for a long time. Therefore, the petitioner, after about 5 years, knocks on the doors of the deputy commissioner by presenting an appeal against the order of dismissal.
Not made known, Andre, were you working or were you not working?
The whole problem was after the inquiry was concluded, where they were not resolving my duties as virtual party. Then they never served the copy of order of dismissal.
Fair enough.
By the writ petition, that is what my learned friend said. We filed the writ petition before this one will go in respect of another communication. Then they brought up saying that there is already an order of dismissal of the service. Then I went back to the appellate authority. Then we went back to the appellate authority and said that this is what has happened. I was because I myself, the manner in which the managing committee has treated me, because it's a pious duty which will be rendered by a concerned person. The managing committee treated him so badly. That's the reason. This person who is now the appellant before this honorable court is largely responsible for whatever state of affairs which happened in the temple. Because he was the president of the managing committee. He was the chairman of the managing committee. Then after having said that, your lordship will see what is the direction given. Paragraph page number 37. An inquiry report. The inquiry report shall be furnished to the petitioner within a period of 4 weeks from the date of receipt of copy of this order. Petition shall be permitted 4 weeks thereafter to submit a reply. Both respondent in 4 weeks shall after the submission of the reply pass appropriate orders in accordance with the bearing in mind the observation made in the course of this order. All other contentions except the one which is considered in the subject petition of both parties is kept open. Because after this, what happened? They also participated. After that, there was the order which I have now passed on to your lordship. That was the order passed on September 1/9/2023. This order is passed. This order they have already challenged before the appropriate authority. Now he cannot come and say that the denials should go. He has prepared an appeal because he has already chosen the forum where he has budgeted. Virtually he has accepted the orders of the learned single list. Now he cannot come back and say that no, I don't want to do that.
Appellant has challenged it before whom?
Commissioner of Endowments.
Whatever contentions he is raising now, the same contentions is required to be urged there.
All
Section 16(2) provides that appeal should be filed within 30 days. It is not instated that he was not aware of the dismissal order at all. Then he filed the appeal after a delay of nearly 5 years. The authority held my lord, he has not explained the delay at all. then dismiss the FA on the ground of delay as well as on the. Now, the learned single judge does not consider the question of delay at all. He says no, because the merits are considered, automatically delay is condoned. That is not a proper. Well, 5 years delay has not allowed in this case.
Page 28 and 29, the delay is specifically dealt with by the learned single judge. The bottom of the page, last sentence. It is an admitted fact that the report of the order of dismissal was never made to the petitioner for a long time. It is therefore the petitioner after about 5 years not such a low hardly considered by triggering an appeal against the order of the dismissal. Since
Right.
the application was not the applicant authority, but the commissioner, it was transferred to the commissioner.
Right.
Lord, may I make one submission? All the arguments apart. My Lord, may I please take page 63, the Lord, paragraph 2. Do we need such a concept is what I asked my judge.
Page 60.
Page 63. My Lord, the order of the deputy commissioner. Okay, I'm sorry, Commissioner Hindu Religious and Charitable Institutions.
Correct.
My Lord, paragraph 2. My Lord, the second sentence. My Lord, this may I read.
Right.
My Lord, page 66, my trouble, my Lord. Paragraph 2 and paragraph 3, and I read it to my Lord.
But you haven't challenged.
No, this, my Lord, I haven't challenged, but this is his conduct. This is how he.
So now you are supporting, are you supporting the appellant now?
Yes, because of all.
The authorities have already dealt with this matter. And the
It's
authorities
all
have already
right,
passed an
because
order.
they have not paid attention to it, but since the order of the learned single judge is considered before my Lord, I'd like to make this submission. Though it is remanded back.
We will consider. Like reply. Is that?
Local issues.
No working appeal given in there. If it is so, that is recommended to present and meet a matter. That is the matter, I need to continue to work for.
You don't know. See, this is something. Your statement against his statement. Some material must be there. ಮುಂದಿನ ವಾರ ಹಾಕ್ತೀವಿ ಅವರು ಮಟೀರಿಯಲ್ ತಗೊಂಬನ್ನಿ. ನೋಡಿ, to continue to pass any kind of an order will be touching the rights of either parties. That's only on statements cannot be done. He's saying that he will produce an order. He is an authority. Let him produce the order. You are the authority. Both of you are private parties.
ನಾನು ಅಂತ
We'll ask the authority to explain who is there. We cannot
CEO ಜಿಲ್ಲಾ ಪಂಚಾಯತ್, ತಾಲೂಕ್ ಪಂಚಾಯತ್,
notice
1 to 3.
1 to 3. So and so accepts notice for 4. You don't appear, none of you appear for this executive officer, Jilla Panchayat.
Our panel lawyer.
Nagarajappa appears as prayed for by appellant, advocate for appellant is permitted to serve a copy on Sri Nagarajappa.
ನಾಗರಾಜಪ್ಪ ಅವ್ರು ನೋಟಿಸ್ ತಗೋತಾ ಇದ್ದಾರೆ.
ತಗೊಳ್ತೀರಾ ನೀವು? ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ?
R1 to R3.
Miss so and so accepts notice on behalf of Sri Nagarajappa for R1 to R3. Whatever that you want, please produce the record. Yes. ಆಯ್ತಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ನೀವು ಯಾಕೆ ಗಲಾಟೆ ಮಾಡಿದೆ? ಅವ್ರ ರೆಕಾರ್ಡ್ ತಗೊಂಡ್ಬಿಟ್ರೆ R1 to R3 shall produce the records 2 weeks. ಅಲ್ಲ
ಎಲ್ಲ ತಾಕದ ಮೇಲೆ ಕಂಡು.
ಹೌದು, ಬರೀ ರೆಕಾರ್ಡ್ ಬಟ್ಟೆ. Of course, we'll fix it. 12th March.
Based on the proceedings. There is a completed the departmental inquiry within 1 year. Still there are not going to comment.
Notice. VVMP. Notice.
Notice.
It is not maintainable for 2 weeks. That is incorrect. We have got an order.
No, please let her say something, then you can respond. Wait for a moment. What is the order?
This one of the court said that para 5 page 24 so saying that there was an instance of national justice violated. So there's no notice given cancellation of county or clear was not right. It was violation of the instance of national justice. Para 5 page 24 was this is the new order dated from the right part. The liberty of the response issue affects local interest.
So now what has happened?
So my notice is because the lawsuits I filed an objection straight away. Matters were no other than I'm not given my form C license given. It's an internal communication. The form C had to be signed by the district licensing authority. The member secretary, the senior authority, the member secretary, it's an internal thing. How am I responsible for the cancellation of the license form C here? So in view of that, I participated to make a new order in past over in my hearing. Not form C is granted to me.
Yes, what?
Between 20 kilometer radius from KRS. Then a suspension order was passed by the DIS. The virtue of that, not all the pressure and warrior suspended.
No, we are not on that. Now, para 6. Para 6, please listen to us. Para 6, page 24, what have you got to say? Good.
And the complainant.
1 minute, 1 minute.
Middleweight order.
1 minute, let us see what you have passed.
I'm not sure.
Examine that and make submission. See, learned DA has filed a memo and submits that order of the honorable single judge. No, order dated 16.
ಇಲ್ಲ ಇದು division bench.
The order dated as per Annex A. Applied for safe complainant. Master on date.
Standard state foreign, the standard state of punishment of money for foreign, it's not crushing act.
Right.
Section 44.
Yes. Yes.
weeks to respond. The election comes, 2 more weeks to the kind of.
What's the matter about? You want some time to file objection? Right.
3 months since.
Election corruption guidelines frame ಮಾಡಿ direction.
All right, 4 weeks as prayed for by Mr. Dadwal. Date has to be. What is a prayer? Remove illegal construction. So what is your interest in that?
It is found that there is a working channel by destroyed and constructed the multi-story building. And
ನಾರಾಯಣ LCT ಅಪ್ಸಾರ್ತಾವ್ ಲ್ಯಾಂಬ್ಸ್ ಅಂತ ಹೇಳಿ ಇಬ್ರು R12 and they encroach.
Of all.
It is found that they have encroached on.
There was a channel, water. Right. So the
1
DA
to
accepts
4.
notice for 1 to 4. Sri Chandrasekhar is directed to take notice for 5. I will advocate for. Pradeep, all are notified. Is it? Notified.
5, 6, 9.
Because otherwise Pradeep Kumar and R5 would not. Has notice been ordered? How did you serve? No, court notice has been issued.
ಈಗ ಬಂದಿರೋದು first.
All right. So you are appearing for Pradeep Kumar. What have you got to say? What have you got to say? Are you filing your counter? Let them come back and say what they want to say, then we'll take it further. No? Notice to other.
ಹೋಗ್ಬೇಕು notice ಹೋಗ್ಬೇಕು.
But can we pass an ex parte? You are in public interest. So notice to 12 and 13.
Not at it, notice for 10 and 11.
10 and 11 also you take.
4.
Chief Officer 9, who will appear? The error is the note.
Chandra
That's the
TMC.
director to take. Yes. All right.
Because it's for drafting of guidelines for the child. The psychological aspect of the child condition. The Union of India is already, the draft guidelines are already in pipeline. So they seek about 8 weeks time to place them.
Your Government of India. All right. So and so for Union of India. Your Sadhana Desai. Sadhana Desai for Government of India. For Union of India seeks 8 weeks time to place the guidelines
And rules.
guidelines on record for the guidelines for child custody on record. Granted. Same thing. This is same because
ಅದರಲ್ಲಿ
please find out from
ನೋಡಿ ಅದರಲ್ಲಿ
proceeding applications.
ಆಫೀಸರ್
Officer file ಮಾಡ್ತೀನಿ.
ಆಫೀಸರ್ ಫೈಲ್
Official
ಮಾಡಕ್ಕೆ
serve. Yes. Next. No. 14 March, right? 27 to.
8 weeks.
Correct. Or 8 weeks ಕೇಳಿದ್ರು. Government asked for
ಫೆಬ್ರವರಿ ಮಾರ್ಚ್ 8 ವಾರ
8 weeks ಕೇಳಿದ್ರು. Next.
ಚಿತ್ರದುರ್ಗ ಮಠದ ಕೇಸು
ಆಗಲ್ಲ
ಕಂಟೆಂಪ್ಟ್ ಇದು ಬೇಗ ಅವ್ರನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಂತ ಬರ್ದು ಇಂಟರ್ಫಿಯರ್ ಆದ ಅಂತ ಹೇಳಿ
What have you got to say?
ಕಂಡೀಷನಲ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ಸ್ ತಗೊಂಡು
Short accommodation.
For what?
For tendering roads, remorseful and unconditional. He is a resident of Louis Roads and he is aware of roads, the consequences of rating such letter. He was roads.
All right, when will you file?
Next week.
Wait for Mr. Subramanian next week. This is Sri Subramanian submits that accused present. Sri Subramanian submits that accused desires to file an unconditional apology in this court next week. Date.
This order. First order, the order is that. Direction was to consider the. But the earlier order, the accusation was squashed. Challenge by media before this court was interview was dismissed. Yet I prepared a special petition that came to be dismissed only on
Notice.
13th.
Arun.
Mother undertakes a part of her regulation, Monday to Thursday of the federal law, and on Saturday from morning to evening.
ಚೈಲ್ಡ್ ಕಸ್ಟಡಿ ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕ್ತಾರೆ
The very next day, she needs an email.
ಫೈಲ್
Filing for the court, filing for the party and the county.
Yes, what I got to say? You're appearing for who? You are. Notice is ordered.
ಆಫೀಸರ್
Okay.
Not it. All right. Notice.
So, there are two of them.
Yes, we'll take their appearance.
they will take by notice ಅಂತ ತಗೊಂಡು
So and so undertakes to file Wakalatnama on behalf of accused. Yes, what have you got to say? You have a copy? You got a copy of this? Please take a copy. Complete your instructions and come. All right?
Just a Monday, so 1 month I was in child, but order the court being written.
All right. Please complete your instructions at the other one. Take on date. Right.
51.
No, what are you challenging here? What are you challenging?
Judgment passed by the district court. Then like it said that then was concluded.
It was not indeed.
It's similar. That, I mean, I just need to show that you are considered order member.
No, we are asking a question on fact. According to you, the learned judge has passed an order on the premise that it was converted.
Yes, sir.
Has it been converted or not converted? So, no, but to record a finding, there must be some material for the learned. What is the material?
Yes. Right. We go to your district court order. I have taken your order, conversion order itself,
All right.
which I have told you. If you are election. Election. Page 208.
No, we can read Kannada itself, no problem. All right. And doesn't matter.
There's no objection from your student side that any issue with the transaction. The page 2040. It has been issued by Office of the President so they have on
1970.
1970. Just your first condition. Number 10, which as per section 95 to 95(7) of Karnataka Regulations. I will take your other conditions also. Karnataka state law, it was earlier next to state. In 1970, when this conversion order was issued, I mean, initial issue. So, to say that this is conversion as section. Then your next year, next conversion. The conversion fee for every seats that we sold to as per section 107(1) and amended this 1984. You know, someone is passing this conversion order in 1970. Same piece. Then we are further. Again, we are it's condition finding. The food corruption be reserved as per section 67 of Karnataka Land Revenue Act 1964. So again, we have Karnataka. Then we are the road market, 6th condition. The road market should be reserved as the central development authority, related to the diamond development authority. You know, the act came into effect in 1976. I told you the road government. So, if here you can write.
ಈಗ admit or you notice ತಗೋತಾರೆ ಇವರು notice arbitrator
Yes, we get the point. Yes, is 1 minute. Yes, sir.
The word was passed. The notification officer holds that it is not a non-resident within the urban area. That is not municipal area. And not the reserve not that it is entitled to not the amount as an urban. That is not challenged by them. What happened was thereafter the land acquisition officer goes back on it and he says that I will pay you only as agriculture. This land.
let the R213 also come. Very important.
Ask the CMCA. Ask the CMCA, question of conversion also is not needed because it is deemed to urban land. We have produced it for.
Let 2 and now you are appearing for 1 alva.
Yes, Lord.
So,
And secondly, Lord, what happens is when they have not challenged the award, they can't go back on that award. They have not challenged the award. Award is accepted by them. What happened was we will not challenge Lord that.
we are receiving notice based on Annex 30.
If your lordship state Lord.
Because these like whether it is CMC or not.
No, that's what
Yes, sir.
notice.
Never be for the district court or all people are arbitrator, all people are SLA.
Please take Lord the award at rate 119, 119. They have not challenged it. Once if they have not challenged it, Lord, it becomes binding on them. 119.
Yes, 119.
Is
At 195.
Yes.
Urban land, my lords get that not 197. He says not 6, urban. This award has become final. They will not challenge this award. If that is so, my lord, they can't go back on it.
This is passed by.
But the land acquisition officer.
Level approved by DC.
This honorable court has specifically held, if not the award is not challenged, in fact, not in that particular case, I also placed it for your lordship. He, my lord, wants it to be, my lord, an agricultural land acquisition officer. But in fact, it was an urban land. This honorable court has said you are not challenged that award. Therefore, my lord, it becomes binding on you. This is one aspect. Second is, I have produced, my lord, the CMC, my lord, on 31, 16/8/2023, my lord, we have produced that. There is a gazette notification. We got breaks in the.
What about 16? See, what I want to say now that there are senior advocates, you are not challenging the award.
They are not changed. That means, this award, or the award itself, even now, what we submission with regard to CLC, it was never came for arbitration level and not because your district court. Now, I just remember the logic to look at your district court order. District court order. It's 85. I mean, it starts at.
41, annexure here.
Yes.
You are page 85, paragraph 28. Much argue on behalf of the commissioner that the very conversion order produced by the process government is not a result of either agreement. It was much argued by the advocate for the commissioner that the conversion order produced by the process is dated 20th June 1970. Under order number so passed by the SSR was put it on. It was much argued on behalf of the commissioner that the use of the word Karnataka while referring to the land revenue act, it says so that the documents are created.
ಮೈಸೂರು ಇತ್ತು ಮೈಸೂರು ಬರ್ಬೇಕಿತ್ತು ಕರ್ನಾಟಕ ಟ್ಯಾಂಪರಿಂಗ್ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ ತೋರಿಸಿದ್ರು
Because much after the reset is act number so 1973, which came into force on 21st August 1973. As such, there was no occasion for the President to refer in the H conversion order of Karnataka and the Since the word Karnataka came into effect on January 1970, the H conversion order to be had was certainly a document created something up to 1973.
73 ಲ ಕನ್ನಡ ಮೈಸೂರು ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಆಕ್ಟ್ ಬರ್ಬೇಕಾಗಿತ್ತು
34 but they are not challenged. 37 plot is still lesser scope than even 34. If they have not challenged plot the award, I asked myself this question, but I kept four judgment to the Supreme Court where they have not held. If you have not challenged the award, you can't know. Thereafter come in 37 it's like it. And not only that, I have produced plot the gazette notification issued by the government saying that this falls within the CMC. CMC itself has given saying that it falls within the Nagara Panchayat.
Whether other respondents are notice has been issued.
ಹೋಗ್ಬೇಕು DC ಇವ್ರು ತಗೋಬೇಕು ಈ GA has to take notice DC ಮತ್ತೆ LM
Arbitrator and deputy commissioner and special land acquisition officer. Sarkar, you must say something on this. What do you say for this 1970 that award? Please examine this. You see, you heard the contentious issues raised by both sides and reply of Mr. Narasi. Please verify and accept. That government advocate, sorry, it was asked by Shilpa Shah that
conversion order and
conversion order at
annexure D.
annexure plus D is not a genuine one as the order refers to
Karnataka.
Karnataka
In the year
with a small
1970.
inverted commas, whereas at the material point of time, it was Mysore state. Of the Sri Holla senior advocate submitted that appellant has not challenged the award and
That has become my-
which has become final, and the same has become final. Next, learned government advocate seeks time to complete the instructions and make submission with regard to the
Genuineness of annexure D.
genuineness of annexure D.
One more aspect. Let them also consider. There the government notification should say that what this area falls within the Nagara Sabha. That is so not conversion also is not needed.
ಅದೇ ನೀವೇನ್ ಹೇಳ್ತೀರ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಹೇಳ್ತೀರಿ.
Please.
ವೆಂಕಟೇಶ್ ಭಟ್ಟಿ ಮತ್ತೆ ಮೂರ್ತಿ ಡಿನರ್ ನಾವು ಇದೆ
Yes, we
ಎರಡು
agree.
ನಾಲ್ಕು ಪಾಸು.
Yes.
Next matter.
Which one? Yes.
Some urgency because.
Ah.
Miscellaneous proceedings against the expanded dismissed against the present that will differ. Now the option proceedings are being conducted by the executive board. 13 is the what it is scheduled.
13. Today is what?
What's the what we need to do?
Today is 5th, no? We'll take it up on 8th. Ah. 53 na?
Yes.
ನೆಕ್ಸ್ಟ್
ಅದೇ ಅದು 8th ಏನ 8th. You're out of.
That would be this matter.
Very well. When is it convenient? Monday, all right. Yes. How do we know which writ petition, which serial number? Unless you must move the matter, it must come. Please give it in writing to the RJ or here. Yes. Ah, yes. Ah, yes. Whatever. You have anything more to say? Because we mentioned to the learned senior advocate that we are having heard, we can't just keep on changing the.
There is no change except that I have to take my last to the issue card, which is two word. That's all.
All right. Do it tomorrow, day after, whenever it is. Day after.
The meanwhile, some development is there. Because of in the teacher self condition, friend self condition. He has been released from the he has been asked to take the treatment outside. So that day after tomorrow.
Day after.
That's what. Yes,
The other-
I moved for end of this.
28/7/2.
Great.
ಏಳು.
You can-
No, doesn't.
ಚೇಂಬರ್ ಬಂದಿದೆ
ಹೋಗ್ತೀನಿ ನಮ್ಮ
Sir?